The meeting will be recorded. It's an open meeting here from the Office of Legal Counsel to talk about free speech in classrooms and sort of the relative limits of free speech for faculty and privacy rights of students and so forth. This is in response to some of the messages we've heard about privacy issues in the classrooms and so forth. So at this point, I would turn it over to Bill Throw.
Thanks, Aaron, for the kind introduction. I hope everyone is safe and well. This is an interesting time for all of us, and I appreciate the opportunity to chat with you briefly this afternoon. I want to talk about privacy and free speech, and in that order. So let's begin with privacy rights. I think the best way of looking at privacy rights, whether we're talking about the constitutional right of privacy, the ability of someone to stop the government from divulging information about them, or FERPA, or conceivably, if we were talking about things from a covered entity, HIPAA. But all of that together, I think the best way to look at privacy is to focus on the phrase, who tells your story? And allusion to Hamilton is intentional. If a student gets a good grade or a bad grade, the choice to tell others about that grade belongs to the student, not to the university, not to the faculty member. Similarly, if a student is told to isolate because they are quarantined, because they have been exposed to COVID, and that is an educational record for us, the decision to tell people about that belongs to the student, not to the university or to anyone else. Same thing if the student tests positive for COVID. These are our personal details. Now, obviously, there are going to be times when the student needs to tell the faculty member. If the student is in isolation or quarantine and cannot attend in-person classes for 2 weeks, the faculty member needs to know. Similarly, if the person has to isolate because they are caring for somebody who is ill, then the faculty member needs to know. But beyond that, we really don't need to be sharing the details of specifics with regard to students, or even specific numbers. Now, the standard that the university uses for the constitutional right to privacy, and really also for FERPA and other privacy statutes, is what we call the skillful Googler standard. And that is, could somebody who knows how to run a search engine do a few searches and come up or reasonably deduce the name of the student? If so, then that information should be withheld and will be withheld as we respond to open records things. Now, obviously, context is going to matter there. If you have one student in an independent study, a request for the grades distribution for your independent study is effectively a request for the grade distribution for that one student. What grade did that student get in the class? Alternatively, that, however, if you've got 150 kids in the class, a request for a grade distribution is not likely to implicate the skillful Googler standard. So there are circumstances where disclosure of even numbers in a particular class will result in a violation of FERPA or the violation of the constitutional right to privacy. There are other circumstances where it will not. I think the best way to address this possible thing is simply don't discuss raw numbers or actual grade distributions, and certainly not the grades that individuals receive. Also, in this COVID-19 era, the university is regarding all of the student testing information as an educational record to that student. So if there are 5 people in your graduate seminar and 2 of them have COVID, under our standards, you would probably violate FERPA and their constitutional right to privacy. All of this, I think, and this is how it's arisen, is the free speech rights of public employees, including faculty. And the Supreme Court has been absolutely clear for the last 50 years that public employees do not forfeit their First Amendment rights merely because they are public employees. Rather, public employees have the right to speak in their personal capacity on matters of public concern. Okay, so for example, if you write a letter to the newspaper, or you write a letter to the governor, complaining about something or advocating a particular policy position, that is going to be protected, and the university or any state agency can only punish you if, in fact, its interest in preventing that disclosure outweighs your interest in saying that. And generally, although it's referred to as a balancing test, generally the public employers lose that equation. Now, not everything that you say in your personal capacity is constitutionally protected, just as not all speech or expression is constitutionally protected. If you're defaming somebody, you're threatening somebody, you're inciting someone to riot, that's not going to be constitutionally protected, and you can be punished. Similarly, if you're violating the constitutional and statutory privacy rights of a student or somebody else in your private expression, that's not going to be constitutionally protected. Okay, we can and do punish employees for that. If someone in healthcare, for example, has access to HIPAA information and they publish that on Facebook, their private Facebook account, in their private capacity, we are going to treat that as a violation of HIPAA. The federal government treats it as a violation of HIPAA, and we are going to punish folks accordingly, or figure out a way to hold them accountable. Now, obviously, within the classroom, folks are functioning within their official capacity as governmental employees, but nevertheless, the university gives all of our faculty members a great deal of discretion in how they conduct their classes. There are circumstances, obviously, where things said in the classroom fall outside the freedom of speech and could result in some sort of sanction. But I think generally, most anything that is said in the classroom, barring harassment or threats or defamation or something along those lines, is going to be, the university is not going to be taking action against it, and we're going to regard that as within academic speech for the individual. Professor Jones sent around all of our policies. I was simply going to talk about speech in the classroom and the privacy interest. I am, of course, happy to attempt to answer any questions the other policies as well. So with that, let me shut up and attempt to answer any questions that folks might have.
Clarify that a little bit, or just go in a little bit more detail about that? What do you mean by inciting a riot? What would constitute inciting a riot?
Well, the standard was articulated a little over 50 years ago, I think 1969, by the Supreme Court in a case called Brandenburg versus Ohio. And it's not only inciting a riot, it's also inciting lawless action. And the speaker has to be calling people to engage in lawless action. Let's all burn down the administration building, for example. And there has to be a substantial likelihood that that will actually that will actually occur, or that people will try to do that. Simply saying it and saying you all ought to go over and blow up the administration building, if that's unlikely to happen, or an attempt is going to happen, then it's not going to be considered incitement to riot, and it would be constitutionally protected. All of these exceptions to the freedom of speech, expression that is outside of constitutional protection, generally have a very, very high barrier, whether it is incitement to riot, whether it is a true threat, whether it is, we presume, the exception for harassment. And that's important to recognize.
You to report aggregate grade distributions on major assignments?
On aggregate grade distributions on major assignments, in responding both to Open Records Act requests that involve both FERPA records and student records, we generally used the numbers of 5 or less. There are exceptions to that, depending upon a particular context, and we got the 5 or less standard from the National Center for Health Statistics. Statisticians debate as to where the line would be. Some schools use 10. We've chosen to use 5.
Thank you.
So, Bill, thanks for the. My question is, we got a message that came down through our dean from the central administration about what we could and couldn't say to our students, hypothesizing about the future of the semester. And people on our faculty were distressed to receive such a suggestion that they couldn't discuss these kinds of things in the classroom. And I'm wondering how you feel this fits into these questions about faculty's freedom to have hypotheses.
Yeah, I'm unfamiliar with the message from Dean Davis. Faculty can.
Just to clarify, it was not her message. It was a message Provost Blackwell wrote and asked the deans to share with the faculty.
Okay. I am, again, not familiar with the specifics of it. I do think that a faculty member has a responsibility to sort of keep order, for lack of a better term, and while I think it's perfectly okay to discuss within the context of a class discussion current conditions on the ground, or where we are in comparison to other universities, for example, it's probably not counterproductive. It's probably not productive to to fuel a whole bunch of speculation. Now, the fact that it's not productive doesn't mean that you can't do it. Again, merely because something is legal doesn't mean, or constitutional, doesn't mean it's a good idea. And, I think all of us have to think about what is the best attitude or way of continuing to have a productive class meeting.
My question is, the recent case of the student organization who put up writing on some buildings, why is that not considered protected free speech? Why would an administrative regulation trump a federal free speech law in that case?
I want to be very careful here about going into details about a pending student disciplinary matter. I also want to be careful about talking about an organization that is not a recognized student organization. With those caveats, our administrative regulations never trump federal law. And I hope that our administrative regulations are consistent with both state law, the Kentucky Free Speech Act, and obviously the First Amendment as interpreted by the Supreme Court and the Sixth Circuit. However, state law and the Supreme Court have made it clear that the university can impose reasonable time, place, and manner restrictions. Saying a message which was clearly constitutionally protected, but did so in violation of university policies regarding the hanging of signs from buildings. Had that student gotten permission beforehand to hang things from a building, there would be no allegations of a violation of student misconduct. If the student wished to express the exact same message in a different way than hanging signs, if he wanted to stand outside the student center with a sign saying the exact same thing, that would be absolutely permitted. But what we have here is an allegation that the student in question did not adhere to the university's content-neutral policies regarding time, place, and manner for expression.
A line between sort of speech that's not permissible and speech that maybe is not productive. I guess the question I have is, do communications, warning people about, this is a privacy violation or that's not, if those don't sort of clearly delineate that, is that productive or counterproductive to not clearly delineate which speech is actually just unproductive versus which speech is not allowed?
Well, what speech that is constitutionally protected is going to be constitutionally protected and is allowed. Now, remember, context makes a huge amount of difference. Okay, for example, a faculty member who gets up in class and says, "Women should not be in this class." Okay, I think probably that single instance constitutes sexual harassment under the Davis versus Monroe County standard. Okay, a student who yells at a female student as she walks past on the way to class, "Why are you going to class? Women should not be in class." In other words, exactly the same thing, probably does not meet the Davis standard. It is not, that one instance is not severe and pervasive enough that it effectively denies the educational opportunity. Whereas when the professor says, I don't want you in class, that's enough. However, again, the mere fact that something is legal or constitutional does not necessarily mean that it it is a good idea. And when the provost says, you know, look, we need to be aware of privacy concerns of students, he is simply saying, err on the side of caution. Now, you know, if you give out the grade distribution for the single student in your independent study or for your seminar that had 5 people in it, we've got some actual FERPA problems. If you give out the grade distribution for a class of 100, we really don't. But nevertheless, the right to tell the story really belongs to the student. And I think the prudent or productive, to use your frame of reference, Aaron, the productive way is to simply stay away from those from those discussions. And you know, I think that's true regardless of you know, whether you're saying, gee, my students really bombed that exam, or my students did really well on that exam, or there was no middle, they either aced it or flunked it, you know, whatever.